Hey everybody, Edo here, and for this week's League video, I want to talk about contracts. Contracts with graphic designers or artists or, work for hire contracts, back-end contracts, that whole thing. Now, this, of everything, is probably has been one of the most requested videos I've had, and I've been very reluctant to do it because honestly, I don't want to be giving too much specific contract advice to other parties. Right? I don't want to just hand somebody a contract and say, this is going to cover you, this is going to make you safe, this isn't going to give you any problems, because it's a contract, and I'm not a lawyer, and I don't want to deal with that. Yeah, a lawyer works on my contracts, but still, I don't want to misrepresent or create any problems. So I'm just very, very reluctant to do that. Nevertheless, so many people have asked, and if it said, just could you tell us anything? I was like, all right, I'll film a video and tell you what I can. Hopefully it's helpful. If you're just looking for a contract, sorry, I'm not linking one. I might be able to point you at some resources if you reach out to me. So first and foremost, let's just talk about when you need a contract. Basically always, I highly recommend having a contract with anyone who's doing paid work for you, back-end work for you, or really anything. Perhaps there are people who are sort of playing it by ear, but the more and more serious you get, the more you want to have a clear understanding with your partner, the person you're working with or hiring, and have clear expectations on payment. And overall, what a contract does, sort of does two things. One, it forces everyone to know what the understanding is. And then two, it protects that understanding if something happens. So it's really important. Honestly, contracts, though, come in different flavors. You might argue a contract could be just a clear email detailing all the specifics between the two parties. Or it could be a plain language contract that feels a little bit more legal and has signatures on it and all that stuff. Or it could be a really sort of legalese, rich, robust contract. There's a spectrum. Now, I'm not representing that an email can hold up in a court of law. I have no idea. But simply having a clear understanding with a partner and what the expectations are will go a long way. And I suspect if there's an email thread between two people with a clear outline of what's happening and a clear outline of expectations and confirmation from both parties, it can be used to say, hey, look, we basically had this email understanding. Again, I'm not saying that's going to end a dispute on your favor. I'm just saying, at least if you're not ready to get part two, that legal half of it, at least get the understanding half of it, right? For me, even when I do have a contract in a process, up front, I have the email thread where we negotiate the terms and understanding, or we do it on Skype, but we establish what the terms are. Then I put it into a document. The document's not meant to surprise the person. It should be covered off. Also, I usually give a boilerplate to somebody I'm working with to say, hey, look, if we agree, it's going to look something like this. Is that going to work for you? Because if it's not, we have to talk about that too. A contract should also really embody the specifics of what's happening and being done, and, shouldn't necessarily, you want to keep the scope really specific in a contract. So what I've done is I've pulled together a little chicken scratch to give me a guideline, but I'm going to give everyone an idea of the main parts now in a contract. So perhaps you have a document, perhaps somebody sent you something. You should look to see if this is in there, and if it's not, perhaps you want to add it. This also could act as a template, as a guideline to an email. All right, so most contracts are going to start defining the parties involved. It'll have the company's name, address, phone number, email, known like in Pencil First Games, for henceforth known as PFG, and then the artist or the contractor name, address, information. Really good to have if you have to, send them a check or whatever, but that's pretty standard in most contracts. And then from there in, it'll say contractor, company, PFG, artist, whatever. They get a term, and that's passed through the rest of the document. The next big piece is a description of services. What are the milestones? What's involved? That's super important, and you want it to be specific. What art assets are being created? Not like you're going to do the art for the game. What does that entail? Well, that entails the box cover, that entails the rules, that entails the components. It's so easy for one party to assume something's in there and it's not, or vice versa. Whether you're on the signing side or on the, like, if you're the artist or the company, whatever, make sure it's explicit what assets are being created. Don't shortchange that. Be specific. Great example would be like game cards. Well, when we started, there were 20 game cards, but while you were working, artist, I added 50 game cards because the designer started to change something. Well, you said you'd do all the game cards. Artist is like, I didn't sign up for an additional 50. You've tripled the work or doubled the work or whatever. Those are frequent examples of how lack of clarity leads to disputes and arguments. And the reality is, you want to work with this artist. You want them to be jazzed. You want them to be engaged. You know, you don't want to get stuck with a confusion between parties, right? So, description of the services. Also, a description of how they're going to be delivered. My expectation is I'm getting PNGs at a certain DPI for illustrations, other words, but I'm also expecting the PSDs as far as I'm concerned. Now, some artists like to charge differently based on that, but the reality is something could happen to the artist. I might need to do things afterwards. I need to have those resource files. Having the resource files is extremely important to a business to manage through any situations. If you're just getting baked art, you might have to do you might be done with the artist, but you have to change a 5 to a 6. You want to be able to have access to that stuff, and you need to be clear because it's not a standing expectation of an artist that that's the case, or a designer, or whatever. You know, I mean, I'm being general and probably saying artist most, but it could be the designer, it could be the graphic designer, it could be somebody working on the rules, whatever, right? Within that, milestones. What work, what payment, breaking it up. Maybe it's, you know, you're just going to do the cover art and it's one thing, then you just have one milestone. But it's good to detail that out so expectations are clear. Also, as part of your negotiation, you're going to negotiate what your payments are per milestone and essentially your payment terms. Typically, there's a pay on sign and then pay per milestone. The artist is going to want all the money up front, and the company's going to want all the money on the back end. You need to find a nice balance, and you want incentives in both places. You might be talking about percentages of a Kickstarter, percentages of net revenue, things like that. That gets a little bit more complicated, and I'll talk about that when I talk about more detailed contracts. But or you might want to have this idea that something happens on the Kickstarter funding. You really need to iron those out and make them crystal clear. As well as payment terms. Is it net 30, net 45, net 60? You don't know what net means in that context. That means how many days the company has to pay the artist. If it's net 30, that means I get your invoice and I have 30 days to pay you. After which I've sort of defaulted or I'm breached, and that should be called out. But payment terms are important. Artists establish those payment terms up front. I hear so many artists complain about not getting paid in a timely fashion. Make sure it's clear what the expectations are. Oh, I thought I was going to pay you when the Kickstarter funded. What? That's in 6 months. On the Kickstarter side, I think it's critical when you're making these contracts. You need to be clear that it may be a Kickstarter, it may not. Set expectations. You know, as an artist, you're paying them. There's no maybe the game's not going to, you have to pay them the money for their work, but the game might not become a reality. It might not fund. So you do want to, in the Kickstarter side, have a little basis for like, hey, we're going to try to make this fun, but it might not. Where the money falls is part of that, but you got to negotiate hard on that kind of thing. You also want to outline the approval process. What is accepted work? You know, is it that the artist sent it to you, or is it approved? How long does that approval process take? A lot of people get caught up in this. I sent you the milestone, I sent you the files, but you're not paying me. Oh, I didn't like something. Well, you didn't tell me that for 30 days. It is important to establish those things. This is like everyday business stuff, but if you're a Kickstarter creator who's doing this on a whim and you don't do it this kind of thing, or you're a first-time artist, you can get into bad situations. You want to look for that information. So perhaps what this is a guide to things you want to pay attention to in contracts. So another piece will have to do with sort of rights and license of the work to the company. As a company, you want to establish, I'm paying you for all this stuff, and I own it. As the artist, that's probably your expectation. If it's not, certainly you want to call it out. But you may want to put it in your portfolio. Being clear and setting those expectations is important, as is determining whether or not the artist can share their work as they go. I see so much board game art shared by artists in artist forums, and I'm like, well, is that the expectation of the publisher? I don't know. I'm not going to get involved, but make sure expectations are clear there. And again, as a company, you want worldwide exclusive rights. I can't remember if it was James or somebody else, maybe Mayday, who got caught because they had assumed it was worldwide, but certain artists in Europe art licensed per region or something like that, and there was a little brouhaha about that. Make sure that's clear. You will want to establish a little work for hire clause that says, especially in almost all these cases, you're not an employee person. There's no workers' comp. You're a contractor. That's an important language you want to protect yourself, and that probably you can just find online. Like, what's standard language there? You want to have you have milestones, you have milestone payments. You want to have a clear understanding of timeline and timeline expectations and how termination works if timeline's not met, milestones aren't delivered, what happens to payments. A lot of artists have gotten into trouble because, they get through something, it terminates, and the contract says it owns backwards for work perhaps that was delivered but not paid for. Just make sure that's clear what that means. I mentioned compensation. That should be in there. Communication, usually it says stuff like communication is by email with these certain email addresses, and perhaps no changes can be made to this contract supersedes all previous emails. You really want it to sort of establish that this is the understanding. So somebody isn't like, well, I signed that contract, but in that other email you told me this. And by the way, artists, if you want to change a contract, make sure the contract changed. Don't just say, well, we had an email thread, or I wasn't talking to you, producer, but I was talking to somebody else on your team, and they said this would be okay. You got to be careful about that stuff. And I don't want this to be onerous. You're working together. It's for everyone's benefit. But this establishes the ground rules, the understanding, so that you can work as a team. Again, what happens with failure to complete? Generally, creators, publishers, have a warranty that the artist is delivering their work, that they have licensing the files, that they're not using clip art or things that they don't have the rights to. Make that really clear. You do not want to be in a situation where somebody has used an asset or had somebody else help that wasn't sort of established a part of it. That's a big deal. So that's what that warranty is there. Assignment, typically that's on the creator side. That's to state that they can they can sell the game to a different publisher. So like you're a Kickstarter creator, you make your Kickstarter, but now as Modi wants to publish your game even after the Kickstarter, you want the ability to assign the rights. It's pretty standard. And then there's usually a miscellaneous part around like what state of jurisdiction it is and sort of legalese. That's really sort of the standard stuff in a work for hire contract. If you're doing a sort of back-end one, that's mostly in there. You're going to establish the engagement, the work, the IP, especially in a case where the IP is already with the publisher. You want to establish sort of the royalty rate or percentage rate. And in that, you need the breakdown of the terms. So if it's not clear, like I'm paying you $50 for this work, if it's a percentage of something, you need it to say what it is, how it works, what's in net receipts versus profit, gross receipts versus, royalty. Royalty on what? Is it on the manufactured price? Is it on the, how that all works is very different in lots of different contracts. And you want to understand it. Based on that, you'll negotiate the percentage. Look, any of those terms can work. You just want to know, sort of do the math and think through what that means to me. I was recently doing a contract, and they were looking at my terms and what's involved. And they were like, well, what does this mean? Is this a good example? And they said net what the Kickstarter is going to make, what they'll make. And I said, that was okay, but let me give you a real example. So I went through and I obscured some things, but I basically here's Herbaceous or Heroes and Tricks, or here was another project. I took everyone's names off and stuff, but here were the details. again, removing percentage, not sharing information from it, but like it basically brought this in. Here's what was flagged as a cost and expense, and here's how it all funnels through. So in this game, those numbers are mostly correct, but I want you to see what's underneath those so you're not confused. I don't want you to be surprised. I want you to just say, oh, this is exactly what we agreed to. Great, right? Because I want to work with people again. You might establish how credit works. That's always something important. Cover, booklet, that kind of thing. Copies. Did you get some free copies? Or does your royalty rate change with success of the title? Those are all things you negotiate. James Matthew has some good material there. I think those are it. There's probably a couple other things I've missed, and certainly you can comment and ask, and I'll answer if I've missed anything. I do want to be helpful. I'm not trying to be cagey about it. Like, the easiest thing does seem to be like, oh, here's the contracts, but I don't, again, I'm not comfortable with people just taking that stuff and using it. It's a reference. I think that, is there any other thing that I'd be aware of? Just talk to the partner, make an understanding clear, make sure the terms are clear, get buy-in, sign off, invoice. Businesses and people who are professionals invoice and send, completion. Both parties want that. I've agreed this is complete. I'm agreeing to pay you. I've paid you. That kind of thing. Subscribe, share, all that good stuff. Most importantly, play some great games. Thanks.